Good night, everyone. This is the 60th session of the Rethinking LUHMANN and the Socio-Legal Research and Empirical Agenda for the Social System Theory seminars. I would like to thank our guests and our audience for the great conversation we're about to have. My name is Fernando Bezzi. I'm a postgraduate in Sociology of Law student here at the University of São Paulo under Professor Celso Campilongo's tutoring. This event is an initiative by Professor Campilongo, Professor Lucas Amato from Escola Paulista de Direito, Professor Marco Antônio Loschiavo de Barros from Mackenzie University, Professor Gabriel Ferreira da Fonseca here from Centro Universitário de Salvador. And this event is happening with the support of the Coordination of Superior Level Staff Improvement, CAPES, the São Paulo Research Foundation, FAPESP, and the University of São Paulo's Law School. Tonight's theme is Prospects for the Sociology of Law. Firstly, we will have Professor Alfons Bora from Bielefeld University, who will present the seminar Observations and Practice, Examples and Future Prospects of Sociological Systems Theory in Socio-Legal Research. Then we will have Professor Henrique Carvalho, doctor from Bielefeld University as well, Doctor of Law and Sociology. Then we will have Professor Gabriel da Fonseca, who will talk about tensions between law and economy in Brazil housing finance system. And lastly, we will have the doctorate student Edvaldo Moita, also from Bielefeld University, who will present the seminar From the Law Beyond the State to the Law Inside the State, Legal Pluralism or Lack of Social Efficacy, the case of street vending in Brazil. Lastly, after all the four seminars, we will open the microphone to the audience, who will then have the opportunity to address questions to our four guests. Well, now I will hand over to Professor Bora for his seminar. Thank you, Professor Bora.
Thank you, Fernando. Can you hear me? Is it loud enough? So I don't have to go on. No. I'm afraid I will bite. Okay. Welcome, everybody. Thank you for the invitation and for the organization of this seminar and this event. The title of the seminar is Rethinking LUHMANN and the Socio-Legal Research and Empirical Agenda for the Social Systems Theory. In this context, I will give two presentations. The first is Today's Sociology of Law in Germany, Reflection and Practice. This is today's title. And tomorrow that will be followed by shorter intervention presentation on observation and practice examples and future prospects. So everything is aiming at tomorrow's presentation. The general hypothesis of both talks says that sociology of law in Germany has been coined by an overall institutional failure due to a seemingly paradoxical cooperation between exaggerated external political expectations of social engineering on the one hand, practical expectations, and exaggerated internal theoretical closure on the other side. In other words, an imbalanced relation between what I would like to call, and I will explain that today and tomorrow, autonomy and practice. The conclusion will be a plea for a search for more balanced, reflective sociology of law. A sociology of law that is able to integrate these two aspects, autonomy and practice, theoretically and empirically. And there's the division between the two talks. Today is more about theory at the end of the day, and tomorrow is more about empirical research. Empirical research can be based, as I would like to argue in the overall context, on such a reflective theory. Today's lecture, as I said, is titled Sociology of Law in Germany, Reflection and Practice, It is based on an article that I have been publishing 2 years ago in the Journal of Law and Society. And as a matter of fact, it is hopefully short report on that article. It has 3 parts. First of all, I would like to make you familiar with the facts, with the institutional decline and failure of sociology of law in Germany after more or less 1945. Secondly, with an attempt to explain this failure from a theoretical perspective, not only as the effect of politics and power plays, but at least to a certain extent as an effect of certain theoretical developments. Closing with, as I said, a plea for what I would like to call a more responsive sociology of law, a requirement of science and practice. Well, point 1, the institutionalization of sociology of law in Germany, roughly speaking, after 1942. There is a prehistory going back to the 19th century, but that's not of interest today. The main point here is that sociology of law in Germany is coined, as I said, by a profound and unsurmountable institutional weakness, if not failure. At first glance, sociology of law seems to be a flourishing branch of science in the German-speaking world. A bit less clear is the theoretical profile of the field, and really disappointing beyond that is the institutional structure. There has been, as I will show you, almost a complete disappearance of research institutes and university professorships in sociology of law over the past few decades. The central thesis, as I already indicated, claims that theory construction in sociology takes place in scientific discourses of autonomy and practice, and these discourses are characterized by contested descriptions of interdisciplinary relations. That is the basic problem. On the level of theoretical self-descriptions, in other words, in reflective theory, such contested descriptions and positions cannot be aligned without difficulty. This institutional weakness, as I will try to show, is connected to the theoretical particularities of the fields. What now follows is a brief overview of the history of sociology of law, institutionally speaking, in Germany. Sociology of law was present in the German scientific community very early after 1945, both in sociology and jurisprudence. Already in the 1950s, a small but growing number of professorships were dedicated to legal sociology. During the 60s and 70s, you may know that already, the field saw a real boost. That was the high season of sociology of law in the German-speaking world. Chairs were dedicated to sociology of law, and political interest in the field increased due to growing trust in social engineering and the technocratic usability of social sciences in general and sociology of law in particular. Sociology of law was a social technocratic instrument for planning and regulating society, for improving society. The academic rise was accompanied by political efforts to reform legal training, by making it more sociological. That was in the 1970s. Everybody talked about the social scientification of legal education. Some even claimed that jurisprudence is nothing else than sociology. Very provocative, but those were the times. However, it was almost completely confined to law school. Sociology, overall the post-war decades, there has never been more than one chair dedicated to the sociology of law. LUHMANN in Bremen. Only one chair for sociology of law in a sociological department. The rest of the history I'm talking about took place in law schools, more or less. Altogether, this growth of chairs and professorships in the 1970s expresses a larger trend in German universities in general, and in sociology in particular, rather than any sustained increase in the field of legal sociology. The exponential augmentation of the higher education system, especially during the 1960s and 70s, resulted in the before-mentioned consolidation of legal sociology as a side effect in absolute numbers only. So this was a tremendous growth of third-side education. And therefore also sociology of law gained some more chairs and so. That was not a particular development with respect to sociology of law. During the last 4 decades, however, since the mid-80s, the situation has changed dramatically. Sociology of law has almost lost completely. It has almost completely been vanishing. And this is literally speaking. There is no sociology of law actually. Today it occupies only a very small number of chairs. It's a 1-digit number. And institutes at German universities. A smaller number of legal scholars still do have a socio-legal denomination or specialization, such as civil law or criminal law combined with sociology of law. In sociology, in contrast, there is still no genuine denomination in legal sociology. In sociological departments in Germany, there is no denomination, no specialization, no chair for legal sociology. Even my own chair in the Law and Society Working Group at Bielefeld University is formally dedicated to the technology assessment. That's where I came from, and where I, as an undercover sociologist of law, somehow try to find my place. In other words, with regards institutional representation, the sociology of law today is barely visible in Germany, despite existing and even some new sparingly dispersed professorships. The field does not have a visible or clear institutional profile. So that's the sad truth that I have to bring to you. Let's talk about teaching. While sociology of law was effectively non-existent in sociology faculties in institutional terms, teaching sociology of law has mostly been a task for jurisprudence, as you maybe know, and the situation, as I learned, is very similar in Brazil. Generally speaking, however, the subject never gained more than a marginal position in both academic fields. Between 1950 and today, sociology of law covered only a vanishing share of all courses in in sociology. Between 50 and 75, there is a counting of sociology of law teaching in sociological departments, and you see the absolute numbers and the percentages ranging from 3% in the early 50s to 1.9% in the mid-70s. Since then, there hasn't been a counting with respect to percentages, so I have absolute numbers for 2003. It's 69 courses on sociology of law, and in 2013 it's 64. But in the same time, you have to know that the overall number of students between 75 and 2003 has quadrupled, and the overall number of graduations has doubled. So the share of sociology of law courses has decreased dramatically, even far below the 1.9%. It's barely visible, as I said. Most of these courses seem to stand more or less isolated, often taught by staff who are not specialized in legal sociology. They do it as a hobby. That's the situation with respect to teaching. Now I will speak about research institutions and funding schemes. In the early 1960s, some socio-legal research was launched at the Social Research Center Sozialforschungsstelle in Dortmund and Münster. Helmut Schelsky, whom you may have heard of, acted as its director between 1960 and 1969, and he attempted to integrate the research program of the Sozialforschungsstelle into the then newly founded Bielefeld University. Well, not very successfully at the end, as you also may know. He left Bielefeld very soon after that time. In 1970, Wolfgang Kaupen, one of the leading figures in German legal sociology, published a memorandum about the necessity of intensified funding of socio-legal research and the establishment of a central research institute for the sociology of law. The idea that legal sociology had to be understood as critical policy advice, I mentioned that before, and as a kind of state-organized research on rational policy making, as it was called, rational policy making, fell on fertile ground. In 1973, the Federal Ministry of Justice started a specific department focused on what they called empirical legal research, Rechtstatsachenforschung, a very specific part of legal sociology, going far back to Eugen Ehrlich and Manfred Hirsch and others. The program lasted until the middle of the 1990s. It funded several research projects. Such programs were strongly oriented towards the notion of social engineering. Government policies, improving society, Willy Brandt, social democratic planning and steering policies. Very rational from that point of view. Although flourishing for a certain time, they were all in all relatively weak with regard to scientific standards and without almost any resonance in sociology. That was the Ministry for Justice, and they applied technocratic programs, but sociology did completely different things. There were no relations between ambitious and comprehensive and complex sociological theory and thinking and these kind of research programs. In 1975, another focal institution started, full of hope, the Socio-Legal Research Group at the Max Planck Institute for Foreign Private Law and Private International Law in Hamburg. Well, however, 4 years later, in 1979, the new directors, they changed the directorships in the meantime, decided not to run the group on a permanent basis. So that was over very quickly. The promising work ended in 1982. Members of the group found a new home at the Center for European Legal Policy, ZERB, in Bremen, where socio-legal studies and basic research in legal sociology could be continued. The group's scholarly program, Cum Grano Salis, existed up until recently, well, say 10 years ago or so, when the ZERB began to put more emphasis on political science. Andreas Fischer-Lescano, you may know, that is, it's not sociology of law, it's very much oriented towards political science, and that it's okay, but you see what's going on. That's the fate of sociology of law in Germany. Another major research program in the sociology of law, especially sociology of law, was launched by the Volkswagen Foundation in 1999. Between 1999 and 1997, the foundation supported over 120 research projects with an overall budget of more than 31 million Deutschmark, more than 15 million euros. At that time, that was a number. For a program called Recht und Verhalten, Law and Behavior. Examples of research themes, just to give you an impression, were witness credibility, drunk driving, bounded rationality and the analysis of state and society, a general theory of criminal law, drugs and traffic safety, trust and the prisoner's dilemma, and dark field analysis, etc., etc. So, you see, that's also very down to earth, a bit technocratic, oriented towards immediate political demands. By combining a certain over-ambitious general approach, law and behavior, And a multitude of research projects that were often only very loosely coupled with the conceptual framework. The program has been described as normalization of legal sociology. On the other hand, due to the high contingency regarding the research subjects, theories, methods, it has also been associated with incrementalism, eclecticism, and a fundamental disorientation. At the same time, you remember, there were no institutes, no chairs. The field had already been vanishing institutionally, so the program was completely isolated, theoretically and institutionally. Scholarly associations. The formation of sociology of law identity has also been organized by scholarly associations for quite some time. They have been quite important in that respect. Where there was little unity in academic life and research programs, the sociology of law has tried to self-organize and thus take visible shape. In the 1970s, the Sociology of Law division of the German Sociological Association, Sektion Rechtssoziologie in der DGS, came into being. In the late 1970s and early 1980s, members numbered in the triple digits, 200 or so. Today it has shrunk to roughly under 100. The last number I had was 80, and I'm afraid it's still decreasing. Also in the mid-1970s, the Association for the Sociology of Law, Vereinigung für Rechtssoziologie, was founded. It collected mainly members from jurisprudence. However, it understood itself not in competition with the sociological division, but rather as a complementary organization. And both organizations indeed have been peacefully and fruitfully coexisting over the years. The association operates today under the name of Law and Society, Vereinigung für Recht und Gesellschaft, and both associations organize workshops and conferences on a regular basis. They have also successfully cooperated in hosting important national and international meetings. The Law and Society Association, a worldwide meeting in Berlin, for instance, which was quite a success. However, again, in both respective scientific fields, in law and in sociology, they have not played a significant role. They are literally non-important. They are marginal in the last decades. Relatively weak with regards to members. I mean, what is 80 or 100 members in comparison to the large associations in law, for instance. They have thousands. Vereinigung der Staatsrechtslehrer. So that is not relevant, frankly speaking. Relatively weak with regard to members and with only a very, very marginal, if non-existing public voice. They are viewed as more or less exotic wallflowers compared to other branches in sociology and jurisprudence. Finally, the German Journal of Law and Society, Zeitschrift für Rechtssoziologie. The German journal has been the central place for scholarly publications in our field since 1980, so now almost 40 years. It was founded by a small number of renowned socio-legal scholars: Erhard Blankenburg, Bruno Otto Brüde, Volkmar Gessner, Rüdiger Lautmann, Jutta Limbach, Niklas Luhmann, Klaus F. Röhl, Hubert Rottleutner, and Manfred Weiss. A mixture of rather ambitious publications, both in theoretical and methodological terms, as well as an open and controversial debate, distinguished the image of the journal from the very beginning. Taking this into consideration, it's not surprising that quite a number of groundbreaking papers and articles in sociology of law have been published in the Journal of Law and Society. I could give you some examples, but I skip that for reasons of time. Again, the counter-argument. However, in spite of the outstanding importance of many papers published in the journal, it has nevertheless been suffering from the more general weaknesses of the field. After the introduction of a consistent peer review system in the first years of the millennium, it became very clear and visible that the number of manuscripts with reasonable degree of scientific quality was far from being satisfactory. There are not enough good quality manuscripts. And that has something to do, obviously, with the situation of the fields. No institutes, no chairs, no young scholars growing up and learning the work and joining us. So, okay. Also in this respect, sociology of law has proved to be a marginal branch in sociology, which remained distant to many of the theoretical and methodological developments in the discipline. Altogether, though being the flagship of German legal sociology, the journal shows the characteristic effects of a marginal scientific field. It has a small number of authors, a comparatively small readership worldwide, a few hundred worldwide, a few 200 to 300, really small, as well as rather weak links to the scientific mainstream in both disciplines. Altogether, we can identify some attempts to create a sustainable institutionalization of sociology of law. The process started with high aspirations regarding basic research in sociology, sociological theory, and interdisciplinary integration. This continued with strong expectations regarding critical science, which would be able to fundamentally change society in the manner of social engineering. It ended de facto in non-durable institutions and in non-sustainable structures, as well as a general depression since the 1980s. Relevant research organizations in Germany, Max Planck Society, Helmholtz Society, Leibniz Gemeinschaft, Fraunhofer Society, only to mention the most important, did not materialize the soaring hopes of legal sociology in the form of research institutes. There is no. Governmental programs and single funding lines, as I try to outline, did not cause lasting institutional effects. They just vanished, evaporated somehow. The field remained rather marginal in the research landscape, and its thematic orientation was mainly characterized by diffusion, arbitrariness, and cluelessness. Today, the downturn is obvious. In German universities, there is no chair dedicated primarily to sociology of law, only as a secondary, subsidiary denomination in some law departments. Only a few professorships with sub-denominations in sociology of law have survived at law departments. In academic sociology, the field of legal sociology is literally non-existent. Only the journal Zeitschrift für Rechtssoziologie is representing the field to some minor extent. So that was the collection of facts to give you some impression and to take away your illusions, if you had some. No, they should be gone now. The question now is, how do we explain this development? And my main point is the following. Not only external, practical, political reasons can be made responsible for the decline, but also internal theoretical aspects that can be found in unintended consequences of theoretical autonomy and closure. So what I will do is not to claim that it's only this kind of sociology of knowledge, this explanation with theory. That would be not very convincing. But in the common narratives, in the widespread explanations, this side is usually be underestimated, if not completely neglected. So I will stress this side of theory. What did theory or theoretical developments contribute to the development I have tried to outline before? The causes of the problem are controversial within the field itself, socio-legal literature, insofar as it addresses the issue, which is not very often, resorts to simple repair and maintenance work in the first order observation. We just improve ourselves and we continue. We are not so bad. That's the usual reaction. Defensive, very defensive. Theory or sociology of science, which would apply a perspective of second order observation, of explaining these development, remains factored out and limited to exceptional cases. So there is no link between sociology of law and possible explanations from other subdisciplines, as for instance sociology of science, that could perhaps be up to somehow uncover deep-rooted explanations for the phenomena I've tried to describe before. The question, therefore, is how the constitution of socio-legal field can be described in a comprehensive way and in accordance with advanced theoretical developments in both legal sociology and the sociology of science. And my following argument will therefore be concerned with the scientific models and theories representing the idea of the sociology of law from the perspective of sociology of science. It's a meta-perspective, it's a second-order description, it's the attempt to get a scientifically sound understanding of what is going on in the science of sociology of law itself. It's interesting to see that academic and institutional success occurred at a time when political expectations towards sociology of law as an instrument of social engineering were at its absolute maximum, namely in the early 1970s. That is an interesting correlation, and it's not by coincidence. That was the golden period of empirical research in sociology of law, as it has been called. Reiser called it 1972, the golden year of sociology of law. In exactly that year, LUHMANN published his Rechtssoziologie, sociology of law. And 1 year later, he wrote a book, Kontingenz und Recht, which only was published 6 years ago, in 1913 or 14. It was published posthumously. He did not publish it. And I think some of the reasons can be found in that particular situation in the early 70s. Systems theory was the only relevant theoretical proposition for the sociology of law at that time. In contrast to the current situation, systems theory was really prominent. Everyone somehow related to systems theory, took position, argued in favor or against. It was very visible in the early 1970s. It was, and as I would argue it still is, unrivaled in its complexity, comprehensiveness, and reflective ambitions. Academic success meant the theoretical progress to an unprecedented level, to a universal sociological theory, which, again, however, at a certain point proved to be dysfunctional with respect to the promises of social engineering that had been made by the field in a broader sense. The tension between these two promises, social usability, engineering on the one hand, and an extremely ambitious and comprehensive universal sociological theory on the other hand, this tension was, as I would try to argue, one reason of the immediate and widespread rejection of systems theory that occurred at exactly the same time. Since the early 70s, since 1974, 75, Rechtssystem und Rechtsdogmatik was published in 1974, and that was Luhmann's reaction on the rejection of his theory from the jurisprudence, from the legal side. So since that time, now I lost my yeah, the tension between complex theory and the practical promises and expectations, not only in jurisprudence but in sociology of law in general, were one of the causes of the problems we were facing since that time. Scientific autonomy, that's the point, scientific autonomy. The self-reference of theory, the closure of theory against its environment, in other words, overruled the aspect of practice in Luhmann's thinking. And that is, as I will try to explain in what follows, that is one of the possible weaknesses or points where systems theory could perhaps be improved to a certain extent. And in order to explain this point, I would now like to make a brief remark on sociology of science. As I have already mentioned, a common and widespread narrative about sociology of law and its self-description attributes the responsibility for the difficulties described before to a certain deficit in legal theory. Its inability to adopt the insights of sociological theory and research. The stupid lawyers not seeing the big advantages that sociology could bring them. That is the common narrative of sociology of law in Germany. I don't speak about other countries. There was a famous book written by Rüdiger LUHMANN, also in 1972. Everything is 1972. Beg your pardon. Soziologie vor den Toren der Jurisprudenz, Sociology ante portas of jurisprudence. The metaphor, the picture is clear. A sociologist sitting in front of the wall of a big city, all the doors are closed, inside are the powerful and important and mighty lawyers, and the sociology is waiting to get entrance, but the doors are not being opened. They remain closed. And this picture, as I would argue, is misleading. It is completely wrong. It's exactly the contrary. Sociology did not and does not until today offer an input to legal sociology that could be taken on board by them and could be played back to sociology. It's a complex argument, and I'll try to develop it. So, in contrast to the widespread narrative, I would like to argue that sociology indeed, and especially in systems theory, that is a bit provocative, I confess, especially in systems theory, presents itself as pure observation without any sensitivity for compatibilities in the subject area. It assumes, and these are not my words, this is Henrique Carvalho, a fundamental incongruence between reflective theory in sociology and the respective subject area, a certain, as Carvalho expresses it, points it, a certain gradient in resonance, ein Resonanzgefälle, between the two, the observing sociology and the fields that are being observed, law, economy, practice, good sense. Sociology supporting the functional subsystems, the subject areas, in their descriptions of their respective environments. So, sociology of law supports the law in understanding its relations with economy and politics and so on. But it does not enable legal theory to seriously reflect itself and how it works and how it functions. That is not possible due to Carvalho, Resonanzgefälle, gradient in resonance. Sociology always remains in a constitutive distance to the self-descriptions of the subject fields, an inseparable otherness. Sociological observation cannot bridge the gap between its observation and the self-descriptions. It can help the fields to understand their relations with other subsystems, but it cannot intervene in the self-descriptions of the field. In other words, it cannot intervene, and it should not, and it will not intervene in legal theory. Yeah, that's the point. This is, in brief, the epistemological point of view in the mainstream of current systems theory, which I will be arguing against to a certain amount. Interestingly, the sociology of science provides us with alternative views, which are also based on systems theory. So you don't have to leave the theoretical framework in order to somehow develop it further. In addition to sociological theories of science focusing on pure or autonomous science, on the one hand, LUHMANN, Kieserling, yeah, it's all about closure, autopoiesis, doesn't allow for intervening in the outside. In contrast to that, and in addition to it, to that hiatus between practical or political world and science on the other. Former student of mine, he's now professor in Bonn, David Kaldewey, suggests a more symmetric sociology of science. LUHMANN's and Kieserling's sociology of science is asymmetric, as I tried to show, a gradient of resonance, knowing everything better than the subject area, but not intervening in the self-description, in the self-reflection of the field. Kaldewey says, no, that's not necessarily so. Systems theory allows us to understand this relation in a much more symmetric way. Both sides being able to observe the other and to take it on board in a certain sense. It's a difficult argument. He suggests sociology of science which pays equal attention to the two sides, autonomy inside and practice outside. He argues that a sociological theory of differentiation, systems theory, hypothesizes binary distinctions and thereby neglects the richness and flexibility of various scientific semantics which produce structural effects in the self-reflection of science. Kaldewey suggests a concept of scientific semantics that combines limitational and reflective functions in the different discourses that constitute the semantics of science. He distinguishes four discourses that characterize the semantics of science: methods, theories, autonomy, and practice. All understood as internal structures of science. So what Kaldewey suggests is that there is practice in science. There has always been practice in science. And his book, in its empirical part, it's very interesting because he tries to show that in a very long line from Aristotle to Thomas Kuhn. He scrutinizes theories of science since the ancient times until contemporary sociology of science, indicating that all these approaches have always thought of a discourse within science, within the autonomy of science, of course, that takes into consideration what goes on in the subject fields, in the self-reflection of the subject fields. This concept of autonomy and practice in a certain way transgresses the systems theoretical approach of LUHMANN and Kieserling, who assume this fundamental incongruence between reflective theory and sociology and in the respective subject area, a certain gradient in resonance. A concept of symmetric responsiveness, therefore, could perhaps serve as a solution for the theoretical disaster in sociology. Such a concept requires not only adaptive alignments on the side of legal theory. Yeah, that's the point. It's demanding for legal theory because it says, well, I know something that I could help you to improve your legal concepts, to change legal theory, and to change things. But also, it challenges sociology on a larger scale. It says, from a point of view of sociology of science, that sociology is able to respond to the self-descriptions in its subject fields. So, in other words, what does it mean? It means that semantics, arguments, positions in legal theory, to remain in our field, can be made relevant for sociological theory. And it's a bit tricky how that should work, but that's the core point. Responsiveness or openness in that sense that this asymmetric relation, the gradient in resonance, somehow is replaced by a more symmetric understanding of the relation between science and its social environment. In order to somehow explain this a bit more in detail, I will now briefly describe against this background the discursive configurations of sociology of law that have been emerging in Germany since 1945 in order to sketch out the relation between reflective theory and institutional development. That is, as you may remember, my main point. Theory and institutions. On the structural level, these discourses, which I will be talking about quickly, are either inclined to a position of strong scientific autonomy or to a discourse of practice, and that is what causes problems in the field of sociology of law. 6 discourses. I identified them. Maybe more. It's not a fixed pattern. It's just a suggestion how to order the development, the theoretical development in sociology of law after 45. A discourse of critique of law. It was very dominant in the 1960s and 70s, an attitude of protest and social critique founded in pre-scientific mundane convictions and political orientations provided the basis for a reflective theory in sociology and jurisprudence, both fields. Empirical science that was committed to social reform programs, or sometimes revolution, or you remember, 68, it was not only about reform, it was about revolution, presumed the legitimacy of social criticism as an intuitive moral certainty. That was the starting point. That was not criticized, it was the starting point. Society has to be improved by means of science. In many cases, a critical sociology of law amalgamated, it merged with the positivistic attitude of social engineering in a particular discourse of practice. The critical discourse remained blind against the genuine autonomy of science, as well as that of the law. Critical theory improving society did not recognize that science is operating autonomously, as is the law. It tried to merge this in order to improve technical, to apply technical improvements of society. It merely conceives of science as committed science, engagierte Wissenschaft, and of law as an instrument of power and suppression. That was the common narrative. Law is nothing else than power, an instrument to suppress people. With such instrumentalist models, there is a fundamental incongruence among all discourses of autonomy in both fields. They are just non-existing. They do not occur. The very sharp and quick rejection of the critical approach by jurisprudence, which is not surprising, the withdrawal of all law departments from any kind of sociology of law that ultimately threatened their existence, becomes easily understandable as an expression of scientific and legal autonomy, if you view at it from that point. It's not only the stubborn attitude of a couple of powerful old men in law, it has to do something with the autonomous reproduction of science. Yeah? And we didn't like it in those days, but the protagonists said it's about arguments. And it's not about power here, yeah? So come back to the arguments and don't try to, okay, thank you, to overrule us. Second discourse, sociology as ancillary science. It highlights the utilization of sociological knowledge in jurisprudence and law. It denotes a different position of science in a discourse of legal practice than in a critique of law. Ancillary science has been the model of empirical legal research, Rechtstatsachenforschung, since its very origin. Jurists define the question, and sociologists, the only purpose of sociology is to help jurists to find answers for their questions. Yeah? It's a subsidiary. The discourse aims at the autonomy of law, obviously. Law is the only relevant reference. But it neglects the problems of autonomy in science. What about sociology? Is there any autonomous development in theory and methods in sociology? Empirical legal research, since its very beginning in the 1910s, Ernst Fuchs, Hirsch, it just doesn't care about it. That's not an issue. The issue is the problems in law, Interessenjurisprudenz and Abwägung and all these things, and how to find better solutions for that, with the help, with the assistance of social sciences. The discourse of steering society by law represents a legal theoretical position that was often also labeled as rational legal policy, rationale Rechtspolitik, the scientification of politics. It's connected to a sociological understanding of societal intervention. However, it doesn't clarify the theoretical implications in general sociology. It's also very strongly oriented towards practice. So the asymmetry is on the other side. The practical needs are the orientation points for the development and the relevance of theory. It strongly referred to practical presettings and thereby missed the autonomous evolution of scientific concepts. In that respect, interestingly, also being a rather conservative project, it's very similar to critical sociology of law. They both have the same problem. Oh, sorry, no. This is a fourth position. I skip it here due to time limitations. That practice as a transcendental reference, that is Helmut Schelsky. And if you know him, you know his position with respect to interdisciplinary research, and he had a very elaborated approach to this science-practice interrelation and how it could be conceived scientifically. I think that was far ahead his time, and it was very innovative. But for certain reasons, Schelsky his way was a different one, and he had no major success in sociology. Quite the contrary. It was not fashionable to talk about Schelsky for quite some time. It's changing nowadays. He tried to, my point here that I would like to make, Schelsky tried to find a balanced position between scientific autonomy and the integration of the environment in practical discourses within society. Transcendental reference, that was a scientific reference. Okay. Observation and irritation, that's systems theory. That's contemporary systems theory, Luhmann, Kieserling, and of course Gunther Teubner, with the claim of this privileged position of science. Scientific autonomy is the main reference, and practice, well, it occurs, it's there, but we don't engage in it. There is this great resonance. Teubner, in his later publication, since constitutional theory, constitutional fragments, he sees it, and for him it's a problem, and he tries to somehow reconcile it. But how does he do it? He reintroduces normative claims. If you know constitutional fragments, if you remember the last chapter, what does he do? Deus ex machina. There is this problem of the individual and the anonymous matrix, as he calls it, and it's nothing else than Jürgen Habermas' theory of communicative action. The individual overruled and overwhelmed by the anonymous, powerful world of the systems. And Teubner, of course, he doesn't say system, he says matrix. But what is it? It's the same figure. And that's not very well justified within the context of systems theory. So what I would say that although emphasizing the autonomy of scientific observation, but without offering a scientific concept of practice that would allow for a balanced, symmetric, responsive integration of the discourses. Also Teutner's position, which is the most developed and the current form of systems theory, as I would claim, is insufficient in that respect. And well, we have been discussing it, and he doesn't deny that in a sense. We are talking about it. Okay, the law and society discourse, I just skip it. It's boring, it's uninteresting, and nobody takes it really serious in sociology. In law departments, Susanne Beer in Germany, she's a member of the Constitutional Court. She's a very, very important scholar, and her group at Humboldt University in Berlin is very strongly dedicated to the law and society concept. Well, anyway, be it as it may, the problems are the same. There is no clear concept of what science as a reflective enterprise could mean. Okay, I stop it here. With these discourses that I have analyzed more in detail in the article, German sociology of law has a multiplicity of identities. There is no single sociology of law in Germany, not only with respect to institutions, but with respect to its scholarly, academic, theoretical shape. It's a multiplicity of different identities which create particular problems for congruence. The identity of engaged social science that uses technocratic models and instruments fails because of the robustness of jurisprudence, which in contrast to some other areas of life does not easily allow for social scientification. Empirical legal research, Rechtstatsachenforschung, lags far behind the development of sociological theory over the time. It's very small scale research. The identity of sociological jurisprudence, rather narrowly focuses on sociological systems theory, coping with the practical abstinence of the latter by submitting to the theoretical fuzziness that comes with, as I have tried to mention before, a hidden normativism in constitutional fragments. In the shape of sociological theory of law, it gains only weak acceptance compared to other varieties due to its reflective self-immunization against socio-legal discourse of practice. A sociological theory that appropriately reflects the complexity of modern law has been developing since the 1970s, more or less exclusively in Niklas Luhmann's work. That is still my point. In that respect, he is unreached. It's unique. However, Luhmann's thinking has been pervaded by a kind of, as I call it, hypothermia with respect to this kind of reflective theory of praxis. This detachment characterizes Luhmann's theory as a whole. The relation between autonomy, science, and practice, environment, therefore has not yet been clarified in the sociological theory of law too. Also unclear is whether this theory could hope for resonance in jurisprudence and simultaneously be a sophisticated and ambitious sociological theory. In sum, it's a fundamental failure of reflective sociological theory. That is the point. There is a part, at least, of the causes of the institutional failure is a failure of reflective sociological theory that leaves a battlefield of incongruent discourses behind. A battle cannot be fought out because the combatants, the reflective theories underlying the different discourses, share the notions of a basic asymmetry. So there is not such a strong difference between them as it seems at the first glance. On a fundamental, structural level, they are all the same. They are asymmetric concepts of science. They only do not agree about the direction of the presumed asymmetry. practice, science, autonomy. The gradient of resonance between sociology and jurisprudence. Such a constellation may well help explain the institutional weakness of German sociology of law, which, after quailing in front of such conceptual challenges, could not significantly mobilize resources at universities, research institutions, or in science and higher education policy. If you present yourself as such a fragmented and controversial field, the probability that you will gain substantive political support in order to survive institutionally is rather low, as I would argue. And that is my part of the explanation. It's only a part, it's not the whole explanation, but it's an important part that usually is not being seen. It's somehow forgotten. From this perspective, the institutional failure of the field is not so much, or not only, an effect of a conflict between disciplines. That's what we always say. The lawyers and the sociologists, and the conflict is all about lawyers. No, sociology, and they claim this common narrative, as I said, it claims that sociology would still unluckily waiting ante portas to be welcomed by the law. On the contrary, I would say the failure and the institutional problems are rather an effect of a deep-rooted asymmetry in reflective sociological theory. It's a problem of sociology, at least to a certain extent. A lack of sociological responsiveness and of practical sense. Okay, coming to an end of my presentations, I would say, given the phenomenological richness and the complexity of the interrelations between social science and the law, the chances for creating more responsive, balanced theories of reflection in legal sociology should be of paramount importance. With the notion of responsiveness in reflective theory, I address a specific discursive combination of autonomy and practice. Within science, we are still always within science. A combination that would allow for external connections, for taking the outside into consideration. That means that from a sociological theoretical perspective, modes of thinking in jurisprudence would make a difference for sociological reflective theory. And that is something we do not have today. Sociology does not say, oh, there is a conflict in legal theory, that's also our problem. While with such a meta-theoretical presetting, a starting point could perhaps, as I think, be gained, which would not only allow the analysis of developments that caused self-immunization of legal dogmatics against social theory. Much more, a sophisticated sociological theory is at stake, one which does not undercut the current state of sociological thinking. At the same time, it should be complementary with the level of argument in legal theory. And this is the point where I completely agree with Gunter Teuber. That is a point that he made in 1914 article. Such a perspective integrates the interdisciplinary and practical performance. That's right, performance as an indispensable part of reflective theory, which establishes the identity of the latter. A scientific observation of law that integrates practical discourse will gain a significant degree of analytical sharpness. It will be able to conceptualize whether and how the relevances of societal subsystems as objects of sociological observation occur internally as an aspect of sociological self-description. Symmetric response. The concept of discourse, that I will be talking tomorrow, but the concept of discourse enables this depth of sharpness. It shows that on each side, scientific observation and legal theory, both equal and divergent types of discourse are entangled. Sociological systems theory, finally, does not exclude empirical and practical references, but rather allows for understanding them in a more accurate way. This will, however, be the topic of tomorrow's discussion. Thank you.
Thank you so much, Professor Bora. Now I will hand over to Professor Henrique for his lecture. Goes like that? It goes like that?
Yeah. We can hear you. Yeah.
Okay, I'll do it that way. So first of all, good evening. I would like to thank the organization to invited me to be here at this event in such a famous and detached venues for the discussion of legal ideas and theoretical ideas as well. And I also thank you all for remaining here tonight to share some ideas of me. I am Henrique Carvalho. I have concluded my PhD a few years ago under the supervision from Professor Bora. And in my thesis, I developed something like a dynamic for the production of legal norms using systems theory, and then advanced a concept of constitution, both not only taking elements of systems theory, but going beyond, as I will talk later. So today, I would like to share with you some preliminary remarks on my current research. So the title is From Sociology of Law to Rechtstheorie, or From Sociology of Law to Legal Theory. So I make some preliminary remarks, and I would like to explain a shift or a change of direction in sociology of law. So in the next, I have divided my presentation in 3 parts. So in the first one, I return to Professor Bora's work and his speech. So to remind in a few briefly words this double isolation from sociology and from law, which is the reality of sociology of law. And in the second part, I address that the problem remains not only in sociology and not only in law itself, but also the sociology of law itself have played a significant role in developing or in constructing this double isolation. And I argue that there is this position, this double isolation is not the only possibility. We leave that, but we can move beyond that. And there are successful examples of theories which are quite well used by legal praxis, and which also took the examples from the legal praxis in order to develop the theory and give back feedbacks to the legal praxis. So this is the second part, and in the last one, I described this intended shift, and I mean precisely. I take the concept from Rechtstheorie instead of legal theory from LUHMANN and Das Recht der Gesellschaft, to the Law of Society, this book. And I outline with some examples how it's possible to construct a sociological legal theory which may be applied in legal praxis. I mean, in the real work from judges, from prosecutors and lawyers. So, then here I begin, very well. So, if one takes
the lecture from Professor Bora, it's possible to observe that I would say the sociology of law is experiencing a movement, you know, from a marginal discipline to a virtually non-existent one. So I took the words. So if one intensifies this situation, one may say that the relative irrelevance of the field of sociology of law to both sociology and to jurisprudence has remained consistent over the years in spite of general academic growth. So neither sociology, neither law interrelates with sociology of law. So that's the point. That's I would say a panorama in which a sociology of law is inserted. So these double isolations, it takes. So I can also remind from Professor Bora speech. It has this hypothermia or this how to say this constitutive distance to law, and on the other hand, if one takes also the text from Gunther Teubner, Law and Social Theory, 3 Problems from 2014, it's a self-immunization from, it's quite, I'd say it's visible for all of us jurists to say that no judge and no lawyer is interested to hear what the sociologist or this legal theorists have to say. It's mainly that. Oh, okay, they are talking about this and that. It's funny. They have these interesting and high complex theories, but I don't really need Habermas to write my sentences. I don't really need LUHMANN to write my sentences. I don't really need to even talk about autopoiesis to write my sentences or my opinions in a certain process. So that's the point. So sociology, it's cold in what remains, in what regards to law, and I would say it's also a problem from the law itself as a very high field, a very complex field, not high but very complex field, that makes it difficult for sociologists. They need to be specialists to even say, I'm talking now as the perspective of the jurists. No? So they don't even know what we mean with this theory in order to, they have to first to complete the bachelor in law. So then they have the very few requirements in order to discuss this theoretically. That's also a important point. This specification of legal theory, of law, the practice of law. But on the other hand, the sociology of law also played a very significant role in this isolation. And so I say that sociology of law, and I also cope here with Alfons Boga's purpose. So sociology of law always posed itself as an alternative. It was almost non-interested to say what law does, or to, oh, there is a problem there and I can give direct answers that may be used or useful. But on the other hand, they were always interested to say what the law or the legal praxis did not do, or what they did wrong, or how they could improve in order to make justice, or to make their work properly. That's mainly the position of sociology of law, in this critical, highly critical, and also, challenging position. Yeah? So I return to Professor Bora once again to give some examples in relation to the subjects that sociology of law studies, and also regarding the discourses that Professor Bora mentioned. So what I say is, when legal sociologists talk about juridical professions, when they talk about reform of legal studies, and when they try to establish themselves in these 2 points as an academic disciplines, they are not providing actually useful information for the legal practice for jurists in the courts. So when they talk about mobilization of law, of gender, and of knowledge and opinion about law, they are also not interested to give, so this may help the public prosecution to write a better beginning paper or uma petição inicial to a legal case. That's not the point. Okay? So if one turns to the discourses, so it's quite clearly to understand what I mean. So it begins with critique of law. No? So it goes on another way to be in a ancillary science. And this points, or you are providing the reality to say that the inefficiency of legal system, of the long time that courts need to come to a solution, or in that point, or you are actually criticizing, saying that what are they doing there? They are well dressed in court, dealing with problems from other people, but what are they doing? They make no justice. So you have justice on the streets, you have justice in society, but you have no justice in courts. That's highly uninteresting for any jurists, I may say, for judges and for lawyers. So the point is, as I said before, as I mentioned it before, is that that's not the only solution. This is a panorama. This is a photo from the today's situation. But I can quote, and I will do in following, some examples of legal theory which is extremely highly used. But afterwards I'll talk about a little problem that these both examples have. So first I would like to address Hans Kelsen and his pure theory of law, or reine Rechtslehre, and especially in the terms of legal dynamics, of Rechtsdynamik, no? Or so it's quite known for everyone in this room, I mean, that one norm takes this fundament from another one, and they build a hierarchical pyramid, and every single court, every single opinion takes that claim to talk about validity, to talk about efficacy. I'm sorry about my translation, so to talk about validade, eficácia, in good, in a very good Portuguese. So, the second example, the Robert Alexis theory of fundamental norms, the theory der Grundrechte. So, Robert Alexis, he took the praxis from the German Constitutional Court, translated that in a theory, and related to fundamental norms, and this triggered in this group, the Society of Lawyers, in the legal praxis, a enormous relevance to concepts like ponderation, Abwägung, balancing. Yeah? So I take, and he develops a a formula, I mean, a method to solving complex, so this tri-dimensional concept of proportionality. Ja, so Erforderlichkeit, Geeignetheit und Verhältnismäßigkeit in eigenen Sinne. I'm sorry, I don't know the translation of these concepts to English.
Adequação, necessidade, proporcionalidade, sentido.
Yeah, this is auf Portuguese. No, this is Portuguese. Okay, so these examples, they are today, will be tomorrow, present almost everywhere in the world. I mean, in Occidental world, in this tradition of continental law. They have, I might say, two negative aspects. So, you don't ask a judge what is a fundamental norm, what's a Grundnorm. that's beyond, that's another point. And you don't ask them as well, I mean, in general, about the discourse rationality lying behind proportionality and balancing. Yeah? So, what I would like to say that now I anticipate the concept of Rechtstheorie. Rechtstheorie, so LUHMANN says, is a very heterogeneous field relating to the legal praxis, which is orphaned from a consistent philosophy. And here I mean, with that I mean that these theories, they are very helpful to jurists in the praxis. They succeed in doing that, but they have this side effect. They fail exactly in what concerns to its normativity, to its ontological side, to this metaphysical foundation, and then they leave orphan, a second meaning for that word orphan. They leave the jurisprudence or the legal praxis orphan from foundation. And that's my point. So then I turn to the third part of my speech, and I say that the central point here is that instead of a sociology of law which insists in offering jurisprudence information about what they don't do properly, or about change they should engage on in order to properly function, sociology of law should turns towards the legal praxis in order to describe or to point out what they do and provide direct answers to issues emerging directly from legal praxis. It may be boring up to sociologists. Okay, we do not want to go down there to understand what they mean with I come to the examples to come to these very specific concepts of legal praxis. So, as an example, the concept of litispendência. Litispendência para o português. This is a concept that's highly difficult for non-jurists to understand, and in this non-jurist space I include also the sociologists. So, I say that in this perspective, revisiting social legal research, so then I come to one of the main concepts of this seminar. No? So, revisiting social legal research, it may engage on a shift on this theoretical level, coping with the previously sketched negative panorama from Alfons Bora, that I say, in order to advance a turn regarding the interrelations between social theories and legal praxis. That means to develop a social legal theory, and using, I would say, elements from systems theory as well, as I understand it as a fairly developed social theory which is able to bring elements to develop that social legal theory. So, then I move to examples. So I take first a few examples from my PhD thesis, and then which are quite general, and then I come to more specific examples. So first, the concept of legal norm. It's in the center of every legal theory. So if a sociological theory addresses the concept of legal norm as a special type of normative expectations. So namely, the one which is produced in certain conditions, so political or procedural, in quotes, that relies on centralized power to its implementation. And third, has its origins in one or more social fields as sources of incongruent normative expectations. So in that sense, I said 3 points that is used by jurists, but they're not explained as theory. So yeah, we do that because we do that. But what I say is that the sociology, the systems theory from Niklas Luhmann, you take that at a departing point and go on. It's possible to explain what that actually means. So in the legal practice, one would say, I'm not doing because I'm doing. I'm doing because I see the interrelations, you know, between norms, what happens in economy, what happens in health, and what is turned in terms of legal norms which are implemented with political power. So, an example that from this relation to the social fields is, so no legal norm has its source in law itself. Law produces norms, works with norms. Politics develops also norms which are directed to legal system or to law. But it is always a reaction to a given incongruence involving one or more social fields. So as an example, I mean that it's not the law or the legal system itself that produces a demand regarding the creation and protection of a legal person, uma pessoa jurídica, Einheitsperson. For justice, for law, it receives a demand for protection and for stabilization of certain incongruences that arise from other systems. The second example, I'll talk about constitution. So, constitution, yeah, it's a legal norm. So, if it's a legal norm, it also may have this connection to social fields as well. Yeah? So, if here we go beyond Luhmann in the sense that's not a very strict linkage between law and politics, but we say that it also has a significant and abstract connection to other social fields. That's a constitution, so I address in my work with a first dimension, this political and legal, and a second dimension, I mean social dimension. So this is it has very it is written in the Constitution. So I say the right of property, it protects the economy and relates the economy to other fields, so property. Religious liberty, the liberty of expression, so you can talk about art or you can talk about politics. So family, the liberty to freely plan a family. And not to mention the obligation to exercise democracy, to make this political system work in this functional, differentiated way, as the sociologists would say, and also to limit it towards the abuse of power. So all this that I said, it may be understood in a very modern concept for jurists, and one of the authoring comes from this faculty actually. So what I said is the constitutionalization of legal fields. It's the constitutionalization of civil law. It's the constitutionalization of civil law in the protection of family. It spreads its constitutional elements towards the field. And that's used in decisions in courts. So here we have an explanation that's actually useful for that point. So I mentioned here, as I'm talking, I talked about authoring here, this professor Maria Fernandes Hironaka, and also a colleague in Rio, Tepedino, with Italian, also connections with Berlingueri. So, I gave some abstract examples, and then I want to go a little bit specific in is a legal field, which is criminal law. So, okay, if you talk about protection of economy, you have property, you have civil law, that's all right. If you want to talk about health, yeah, there is a very complex setting of systems that is always there, also science. And what does, to which legal system is related to criminal law? To which social system, to which field in the society? I say, if one wants to address that, they have to look to the concept of Rechtstheorie ou bem jurídico. What are these Rechtstheorie? They are actually social elements that in incongruences towards what should be protected or not be protected are selected in a political or in courts also. They do that, here in Brazil at least. This Rechtsgut is protected, selected and protected as normative expectations. So I come back to the concept of normative expectations as produced, as created, as developed, not created, I mean developed by Niklas Luhmann in that in the book Sociology. No? Firstly, so criminal law may be a stronger protection, as we may see in the other fields. Now, a more down-to-earth example. So, if one talk about here is the fourth example. So you go to crime theory or Handlungslehre in German. It's may define it as a technique used in legal doctrine to qualify a given act as a crime. That's what is used. So a given act is qualified as a crime when it purposes all the levels in this crime theory or Handlungslehre. So one of these, the first of these items, it's related to the Tatbestand or to tipicidade in Portuguese. And since the finalist, or also in some extent in functional theory, it comprehends two concepts. I mean, omission als Unterlassen and negligence as Verlässlichkeit, ou para os brasileiros culpa. these two concepts, they are still controversial. We are in 2019, and we have still a action theory in criminal, in crime theory, which is not able to define social in the what happens in the earth. What is an omission? What's an omission? It's a non-action, they say, with ground in act theory or action theory. Yeah? So, I mean, and what is omission? It's actually a transgression against a normative expectation. A normative expectation. You should not do that. That's expected. So, I mean here that this concept may be actualized and actually help the judges when they say what they did not. Okay, I will not only use this norm because its norm is there, but I can understand and I can use that in my to fundament my decision. And also when it comes to negligence, so this objective obligation to avoid. So for der Wahrheit und Vermeidbarkeit in German. Both these concepts, what's the objective obligation? It's also the stabilized normative expectation in the law, in the law. So it's a little bit complicated to speak that in English. So to sum up, I come back to Professor Bora to say that advancing these, so if one makes this shift, if one, instead of saying what they don't do, what they are not doing properly, start to clarify, to give some answers, not in the terms of this ancillary theory, the hashtag Sachenforschung, but to address what may be used in legal decisions in the praxis. So this sociological Rechtstheorie may contribute by integrating a scientific observation of law that integrates practical discourses, and may, doing that, gain a significant degree in analytical sharpness. I mainly address the point in one hand to what sociology can provide to judges or to prosecutors or lawyers. But in doing that, I took the middle element, I took the sociology of law away. I just connected legal, sociology, and law, and backwards. That's the point. I didn't move from sociology of law to legal praxis. I took away sociology of law, so the sociology may help that in doing so. And then may be, again, so as I said, it's in preliminary remarks. So that's the point. I took a highly point in this way, but I may indicate that the gain in social theory may be as well achieved. So I thank you very much for listening, and I am open to questions and criticisms.
The questions will be
taken
afterwards.
Thank you.
Yeah, sure. No, it's just Gabriel.
Thank you very much, Professor Henrique. Now I will hand over to Professor Gabriel da Fonseca for his lecture.
Thank you very much. So, first of all, I'd like to say that I'm really glad and happy to be here with Professor Alfons Bora, that guided me during my short period of research at the Faculty of Sociology of Bielefeld University. It was a really important period for me and my research. And I'm really glad to be here with some friends that from Bahia, of course, and other places that came to see Professor Bora, of course. We have here people from different places of the country. It's important to say that. Ceará, of course, Rio Grande do Norte, and so on, Pernambuco. And I'm happy to be with Edvaldo Moita, my friend, my colleague, and Fernando Bezzi also, and Henrique Carvalho. It's a good opportunity for me to share some points of my research. I will present today some aspects of my PhD research that I finished in the beginning of this year. And I selected this title, that is Tensions Between Law and Economy in the Brazilian Housing Finance System. And I tried to develop a kind of socio-legal research. I don't know. I'm not sure about sociology of law more about after the presentation of Professor Alfons Bora, but I will try to present some irritations maybe from some inspirations from sociology and so on. And I selected this specific case study to try to understand the relationship, the tensions between law and economy, two functional systems. I will explain a little bit more about that. So, but before that, I want to present some aspects, some concrete aspects regarding the Brazilian context. Because the Brazilian housing finance system was created during an interventionist state of Brazil. It was created by law in 1964, in the beginning of the military dictatorship of Brazil. And it had two objectives. On the one hand, the idea was to fight against a huge social problem of the country, that is the housing deficit, and on the other hand, to create jobs, to improve the market, and so on. And it had, as the authors say, a kind of economic success, as it created jobs, it offered houses, especially for the middle classes, and it helped companies to grow up in the country. But we had also a kind of social failure. As we know, we had important grow up of the slums in the country, the favelas. So if we have a look at these numbers, we can understand this problem. From 1964 to 1986, we had 4.45 million houses financed by that Brazilian housing finance system. But only 33% to low-income families that receive 1, 2, 3 minimum wages. And more than 10 million houses were self-financed and self-built. So those families were kind of excluded from this formal financial system. They had access to house by informal ways. So it is the numbers of this failure. And from 1990s to 2008, we had a kind of period that the literature says that is a kind of neoliberal period when we had a neoliberal agenda, so movements of privatization, impacts connected to the economic globalization, and so on. And concretely, we had some changes on legislation to protect financial agents. It was a demand that they were interested to change the law to improve this market. And we had some kind of changes to protect them. But as we know, in 2008 we had that important international crisis, and because of that we had a new solution in this Brazilian housing finance system that was named Programa Minha Casa Minha Vida, or My House My Life program, a kind of social program directed to the neediest people of the country, a kind of Keynesian strategy. So it's the same objectives, to fight against that social problem and to try to improve the economy, try to fight against the economic crisis. And the numbers are kind of impressive. We had from 2009 to 2014 3.6 million houses produced by this system. In 5 years we had a huge number of houses produced, and 46% for lower income families. So we had a kind of important change in that moment after the crisis. And one interesting point of my research is that in the beginning of this decade we had these housing social rights put in the constitution, but a kind of economic crisis seems more important to change the social policy in the country than this change on the constitution. Yeah, it's important to say also that although we had that period connected to the neoliberal agenda, until nowadays we have a specific public bank, a federal bank, that is the Caixa Econômica Federal, producing more than 70% of these houses in this Brazilian housing finance system. So the public participation is important yet here. And although all those changes and attempts, we have yet in Brazil a strong housing deficit that hits the sum of 6 million households, which represents 9.3% of the country's stock. We had a small evolution here. We had before the Minha Casa Minha Vida something like 10.3 or something like that. So 1% was changed here. So it is the context of my research. And given this context, I tried to answer a specific research question that kind of guided my text. And the question was, does the political and legal interventions crisis in different spheres of social life, and especially in the housing area, lead to replacement of the citizenships and social rights logic by the markets and consumption logic as the way of social inclusion in Brazil? It's a kind of diagnosis offered by authors from urbanism and architecture, and somehow connected to critical theories and so on. And they say that there was this kind of replacement here. So we had before a kind of universalistic logic connected to the citizenship and social rights, and it was replaced by the markets and consumption logic, a selective way of inclusion, connected to the market and so on, connected to the economic globalization, connected to that neoliberal period. And I tried to rethink this diagnosis. And to do that, I selected some case, I selected a specific case study, as I mentioned, that was the Brazilian housing finance system. I based my research on this a specific theoretical framework that is the systems theory of authors such as LUHMANN and so on. But I tried to do something more empirical. So I tried to get all those abstract concepts and try to develop empirical research, and I was kind of inspired by the sociolinguistic studies of authors such as Professor Alfons Bora. So I tried to use some concepts such as social position, discourses, and yeah, I tried to mobilize this in my research, as I think that will be clear soon. And concretely, I used some specific techniques. Of course, I conducted a literature review, so of course that I had access to articles, dissertations, theses, and so on from sociology, law, urbanism, geography, and so on. I tried to read economy also, everything that was kind of connected to my case study. And I developed also a documentary research, and I searched for those documents on internet, on official websites of some organizations that I will present soon. And I asked for some questions to public institutions and so on. And some of those documents I collected also during interviews that I conducted. So I conducted some semi-structured interviews with judges, with lawyers of social movements, of business associations, and also project managers and directors of business associations and companies of the construction sector. And then helped me to have access to some documents also. And of course that during these interviews I had the opportunity to observe, to directly observe this reality. And of course that I tried to do a LUHMANN stuff connected to the second order observation. So I tried in some extent to make science. Yeah. So I don't know how many time I have, but I will try to be fast here. It's important, some conclusions of my research is that one is that this specific social policy is connected to the intention, to the objective to promote inclusion of people in economy and law as contractors and owners in the Brazilian case, as we know that in other countries we have also a social rent as an important solution for this social problem. But here in Brazil, the tradition, the history is connected to a specific economic solution that is helping people to buy their own houses. So the idea is connected to the private property and to pay for this private property by long-term installments, and so it is an economic solution for a social problem, an economic solution connected to a specific social policy. So I think that it is a kind of conclusion that I had during this research, and of course that I want to discuss with my colleagues about these kind of aspects. It was a social policy created during an interventionist period, an interventionist state, and It has a kind of declared function connected to the idea of inclusion. But we had, as I mentioned, a lot of exclusion connected to this social policy. And I developed this empirical research, selecting and kind of reconstructing some social positions, and I named those social positions as global political economic organizations and global political legal organizations on the global level. And those organizations have equivalences on the local level, as I will present soon. On the global level, we can say that organizations such as World Bank, Inter-American Development Bank, the Organization for Economic Cooperation and Development, those organizations could be named as global political economic organizations. As we can see in the discourses, ideas such as housing as a product of consumption. So the idea here is that we should improve this market to make this market works efficiently. And to do that, the countries, the governments should reform their policies, their institutions, their regulations. Especially those countries, those developing countries. So the idea is the freedom. The idea is to include people by the market. So if you put the market to works efficiently, you will help people to have access to house. This is the idea of inclusion by market and by consumption that we can see in the global level. And in the local, in the global level, we have also the global political legal organizations. That there are some connections between the discourses of those organizations, but there are many differences also. We have examples here of this social position: United Nations, the UN Habitat, that is connected to the United Nations, and the Organization of American States. And it's possible to see, and I had access to some of those guidelines, technical studies, and so on that they produce to try to influence the reality, the social reality, the norms, the reforms on policies of different countries. So I studied those kind of documents from political economic organizations, but also the guidelines, the norms from the political legal organizations. And those political legal organizations focus their discourses on human rights. So the idea is that housing is a kind of human rights. So the idea is to promote adequate housing as a social right, so to improve the citizenship. And the states commit themselves to intervene in some extent to put equality in around the world. So this is the semantics. So we can see in this global level kind of tension between law and economy, or a kind of tension that we can see looking at some organizations. So it's possible to see in an empirical way semantics, rationalities, logics of economy and law in tension in this global level. And now we can look also to the local level. And I also had access to documents from specific organizations, such as Abrainc and Secov São Paulo, that are two of the most important business associations connected to these construction sector, this economic sector, and yeah, I had access also to some lawyers and project managers, as I mentioned, and I interviewed them also. And it's possible to see in their discourses ideas such as profitability. So the idea is to search for profitability in these markets, so to improve the efficiency of these markets and to fight for more legal certainty, less bureaucracy and less taxes. And they do that mainly by contracting and presenting technical studies presented to legislators and regulators and so on. So it is possible to see this kind of keywords here, this kind of semantics in these organizations. And I also interviewed some lawyers from national social movements connected to the housing area. So I selected the UNMP and the MTST. They are two of the biggest social movements of the country. And I interviewed and I had access to some documents produced by them also. And it was possible to say that they are a kind of local political legal organizations. They are social movements, so they produce protests, they produce kind of direct interventions, the occupations and so on, but they also, as they are organized, well organized, they also impact on legislation, on regulation, on institutional politics. And they had important access to the center of the politics, as during the last federal governments of the country, the doors were open for them, because there is a kind of history between the Labour Party and these social movements. So they influenced the legislation, the regulation, and this social reality. And they use to fight ideas such as social justice, popular participation, legitimacy, and so on. So also we have a kind of tension between law and economy in the local level, looking at these kind of organizations that had important influence on this sector. Of course, that I don't have enough time to discuss every aspect here of this research, so let's just to say that my answer to that question that I stated in the beginning of my presentation was that there are tensions between at least two ways of achieving social inclusion: by social rights and citizenship, as it was possible to see on the global level, and by the other one is by labor and consumption markets, as it was possible to see both ideas on global and local levels. Yeah, so my answer is that it was not a replacement. Actually, from the beginning of this intervention on society, we had both ways of inclusion in tension here. We had a kind of economic strategy from the beginning of this social policy, and we also had a kind of social rights logic here, and it is in a kind of tension during the history. Of course, that nowadays the social rights and citizenship is kind of losing the fight, but yeah, it is something that is all the time on balancing on movements. And yeah, it was what I wanted to present today. This is only a kind of table that resumes everything that I discussed here. I only want to say that one of the conclusions of my research is that these social positions that I selected have kind of main functional systems, politics and economy on the one hand, and politics and law on the other hand, but also some secondary functional systems connected to them, to those organizations, as they also produce kind of technical studies, kind of pedagogical or didactical materials, intervent on mass media by writing articles to connecting this kind of communication to these main functional systems. So it was what I wanted to present. Everything here is also a kind of, I finished my PhD, but I'm trying to review everything to publish and so on. So it would be nice to receive criticism, comments and so on.
Not at this point.
Yes, I can improve this to next articles and so on. Thank you very much.
You can always start a new PhD.
Change everything.
Thank you, Professor Gabriel. And lastly, we will have Professor Edvaldo Moita for his lecture.
Okay, thank you very much, Fernando. All right, thank you very much. I was given a very difficult task here, which is not to present my work, but rather to keep you all awake. I assume that you must be really tired, hungry, sleepy. At least I am. So if I sleep, please, Professor Bora, you can wake me up here in the middle of the presentation.
This is the grand finale.
Yeah.
Yeah.
It was not my choice not to be the last one, so just the hierarchy, you know? I mean, the lowest degree. I mean, I have not finished. I haven't finished my PhD even, so that's what remains to me. If you're not complaining. Yeah, so I brought part of my doctoral research here, which I'm conducting in a joint doctorate between the University of Brasilia, in Brazil, and Bielefeld University. And at least for the past 3 to 4 years, I have been collecting many materials, data regarding my object of study, which is the impacts of informality into the legal system in general, and more specifically speaking, how street vendors, they are dealt with in the judiciary here in Brazil, more specifically in Ceará. That's where I come from. And I'll try to present one of the theoretical discussions, although I think it's a bit unfair right now to talk about theory at this time of the night. So I'll try to sum up in the first part of my presentation the framework, the theoretical framework I will use, and in the second part I will concentrate on the case study that I think it's more interesting to elucidate my points here. And just to make my argument quite clear, I will draw the whole research in the sense from the literature that has been discussed on the development of the law beyond the state and vis-a-vis the law inside the state. And then instead of a legal pluralism, I will talk about segmented efficacy. Of course, I will try in those few minutes to make it all clear, otherwise we can discuss afterwards. There has been a growing literature to describe this kind of set of phenomena of a law beyond the state. And there are many authors that try to describe it in many senses. Some talk about a globalization of law and legal thought. Others speak about global constitution or global constitutionalism, legal and political orders beyond the national state, deterritorialization of constitutional problems. At another corner, we have that's an argument from Professor Thornhill, although a bit controversial, but with a lot of historical evidences, that the global law has developed first, and then the national law, at least in the terms of rule of law. He even says that there is first the notion of a global citizen that allowed, that made possible to think about a national citizen. And the more one deepens into this law beyond the state, or the global law, more one can find many theoretical descriptions of these phenomena. But what is interesting to me is the core assumption behind all these theoretical descriptions, and it seems to be that they point out some sort of a development of the law in which the state does not play any role, or when it does, it just plays a secondary role. It works as a mere stakeholder, either in producing, adjudicating, or enforcing legal norms. That seems to me that the core assumption behind it. And it's here where we find, so mentioned here a couple of times, Professor Gunther Thorne. I think that he has one of the most interesting and accurate descriptions of this phenomenon. His claim is quite famous on the global law without a state. Lex Mercatoris is an example per excellence, according to him. And this law beyond the state, or this global law without a state, is characterized by 4 distinct features, according to him. It transcends the territorial boundary, so it has no core territory. Its sources are not encapsulated in legislative bodies, but rather in self-organizing processes in society. It grows in some sort of a diffuse manner and dependent on the social system. So the law is not only a structural coupling between law and politics, but it can happen with different structural couplings, such as in the case of Lex Mercatoria, it's quite easy because it's law and economy. The case of Lex Digitalis, law and internet, although his claim is a bit more complex and very difficult to ascertain even right now. But anyway, it also has a 4th distinct feature, which is it lacks immunity, given space, so to say, to the need of a coexistence between different sources or different legal orders. And if we assume these features, then of course, Lex Mercatoria would be a good case to start with, because at least according to Turner, it breaks 2 common taboos in legal theory. On the one hand, it creates private orders, especially through contracts and associations, and on the other hand, it claims to be valid outside the nation state. So this is the kind of law that does not need internal state processes to claim its legitimation or its validity to be valid. And his description of this global law without a state, it is built upon a very specific argument, and that's the point of my presentation. If you want to forget everything I said before and concentrate here, I will ask you to do that, because that's where I depart from. So according to Thorne, this kind of law cannot be described through traditional sociological categories such as rule, sanction, and social control, but instead one needs to resort to new sociological categories such as legal discourses instead of legal structures, legal processes. Instead of legal norms, one should use legal or observe legal actions. And more importantly, instead of looking to the function of the law, one should look to the code of the law. So he is worried about communication that distinguishes between what is legal and what is illegal. Well, it is a bit hard to deny that there is indeed this law beyond the state level, and in those new sociological categories they are quite good, we could say, or we could agree to describe this. But what remains hidden in his argument, and that's where I want to depart from, is but what can we do with these traditional sociological categories? If they do not account to describe properly what at least this law beyond the state, so can you use them to describe the law inside the state? That's the question I want to address here. And of course it presupposes another question, which is, okay, what has happened then with the law inside the state, at least for the past half century? And here I will come to my second part. I will try to present you a case study that is concerned with my research, and that pictures, or that at least it gives us a good idea of at least one arena inside the state for which these traditional sociological categories are not, they do not suffice to describe it properly. And before I come to this specific local level inside the state, I need to make clear that you're going to have the same language here to understand what I'm going to talk about, which is informality. The topic is huge, it's highly complex, and there are many different literatures to account for it, but one ground, at least one stable ground to deal with this subject is ILO, International Labour Organization, which has been struggling with this huge thing that is informality. The concept, it was first used in the beginning of the 70s by an economic anthropologist. He was called Keith Haw, and he was in his reports on labor activities in Ghana and then afterwards in Kenya, he used the term informal sector to account for the activities that they somehow or to a certain extent do not comply with the law. And ILO started to use his concept of informal sector, then it dropped out, because when we talk about informal sector of economy, we might be misleaded, because these kind of activities, they are interlinked with many sectors of economy. So ILO started to use the concept of informal economy, and for our good reasoning, they came up with this recommendation, 2015, recommendation 204, giving us a concept of informal economy, which refers to all economic activities by workers and economic units that are in law or in practice not covered or insufficiently covered by formal arrangements. So we are talking about here of activities, labor activities that they either do not comply with the state law, or the law in itself, the text, does not comply with decent work standards, decent labor standards that are produced by ILO. And furthermore, that's a second aspect of the concept. That's the main part of my presentation here, so you should pay attention to that to understand what I want to show. This concept does not comprise illicit activities. Now, so ILO states a strong boundary, it sets a strong boundary between informal labor and illegal activities. So things such as the production, sale, possession, or use of goods forbidden by law, or production of and trafficking of drugs, the trafficking of persons, firearms, money laundering, that would not account for informal work. Well, that's a bit complicated, huh? We are all lawyers, we might get upset by seeing this, but I will come to this problem in a few minutes. Now, just keep in mind that this conceptual enterprise, at least done by ILO, made it possible to calculate informal economy worldwide. So I want to give a big picture of what we are talking about here, to make my case study quite clear, and how it's striking the phenomenon. So, for instance, last year ILO produced a report, you all can read it, right? In 2018, see? About 2 billion people right now, they are working on the informality. That accounts for 61.2% of the whole workforce in the whole world. So we are talking about half of the work population. And in Latin America is an example of that. So if we take this is also from ILO, from 1986 to 1996, 80 out of 100 jobs created in Latin America, they were informal jobs. And Brazil is a representative case of Latin America. If we go from this more global level and we deep down the observation to a more specific case, Brazil it's really interesting how this works. So also last year we had the report. Here is done by IBGE. It's a formal institute, and they have some methodology, but they use ILO's standards. And for instance, last year we had 38 million people working under informality. That is 43% of the whole workforce here in Brazil, which is some sort of a record. So every year we are breaking records regarding informality. So it is indeed a huge phenomenon. And when we talk about informality, we are talking about many different things. And this is just to have an idea, because I want to show you my case, which is a very common informal activity that most of us know, and we can see it in everyday life all around the country, which is street vending. Street vendors, they are typical figures worldwide, that they are mainly used to sell products or provide services on the streets, normally on sidewalks, squares, public spaces, and also normally at a cheaper price than one can find on the formal market. There is a huge literature to get acquainted with this kind of activity in anthropology, in urban studies, but not in law. That is I just want to sell my fish here, not for you. But in law, it's highly difficult to see people dealing with it. Nonetheless, there are many cases that deal, specifically speaking, with this kind of activity. And I could approach it from many different senses, because they use the public space. So when they use the public spaces, they need authorization to do that. Sometimes they sell goods that they are not that much legal. So sometimes they break the penal code. We have tax problems, so we have many different of legal issues here to talk about. And then I just want, so we could make it, so I could make my argument as clear as possible here, which is administrative regulations. So those regulations that will handle street vending under the perspective of the administration of the city. And that's the case I want to show here. It is street vending in Fortaleza. That's the capital state of Ceará. I think all of you must know, at least. But I will talk about Fortaleza here, but I could easily say that is a representative case of the whole country. It is in São Paulo, it is if you go to Belo Horizonte, or if you go, there are many data that I've collected so far, and I could be safe to say it is a representative case. So if I talk about some specific things here, it might be different, but in the core of my argument, it is not, at least so far. And normally, when we talk about these activities at the municipal level or the city levels, especially on medium-sized or more specifically on the capitals, we can find some regulations to deal with them, to regulate this kind of activities. Fortaleza is really nice because we have many different types of norms that are concerned with the street vending, and they range from the most general ones, such as the constitution of the municipality or the code of construction and behavior, so how you can use the public spaces there, until very specific regulations, such as the regulations on the commerce of alcoholic beverage, which is a quite common products sold by street vendors there. But one striking characteristic here, that's what I want to point, and regardless the regulation, it lacks to a high extent social efficacy, to a high extent. And then when I talk about social efficacy here, I'm talking about the three levels of social efficacy. So observation, adjudication, and enforcement. So it happens at least in most of these norms at those three levels. And so just to give you some examples of that, the city of Fortaleza is quite interesting because it provides us with a decree that was issued by the mayor in 1994 that regulates the street vending activities. And so we have a decree specifically created to street vendors, and it's so nice that this decree gives us a concept of what is supposed to be a street vendor. That's the first article of the decree. It is considered as itinerant commerce, any commercial or service activity of a permanent or occasional character exercised in a stationary or itinerant way in public roads or public places by persons who do not have any type of employment or functional link with public or private person. Well, these are very fancy words to say, oh, you're talking about street vendors that they are selling their things on the streets, no? And it is really nice because after this article, the decree provides us with some examples of goods that can be provided by street vendors, such as cigarettes, magazines, books, clothing, and so on and so forth. But what is more interesting is it also gives us some examples of activities or products or services that cannot be provided by street vendors. And we can see, for instance, in Article 2, the sole paragraph, it says that the activity of sale of popsicles, popcorn, and lotteries, when exercised in an itinerant way, is not included in the capital of this article. No? So it's a bit strange. The first time I read this, I was like, oh really? This is revoked somehow, and it was not. So I had to do some interviews with the public authorities to say, well, what is this? Because if we go throughout the city, we can see these activities everywhere. No? So I brought some photos here, so I hope you can see, yeah, because that's a really interesting part. Huh? That's a seller of popcorn in the middle of sidewalk. This is the city center of Fortaleza, and believe me, they are all around the town. And then I asked one of the public authorities, I connected the name, but what do you do when you see them? Because, you know, the activity should not be performed by street vendors. They say, oh yeah, well, we just ask them to leave. So if they stay there, and then we seize their goods. But normally we just have to leave, and they leave the place. But nonetheless, it's you can see this activity all around the town, and it's just regarding this point in which he gives some sort of oral admonition. It is not backed by a law. No? So when a public authority, we call fiscal, sees an activity that is not allowed, he should seize the goods. That's what it states. What is stated there? But anyway, they created some sort of sanction or negotiation to say, okay, please just leave the place because you should not be here. But that does not only happen with popcorn. Lotteries, and lotteries is a much more specific case because it's also forbidden by a federal law in Brazil. It's a penal contravention and a misdemeanor. Only the state can have lottery. But nonetheless, Brazil has what is most likely the world biggest informal lottery, which is called, we all know, Jogo do Bicho, animal game. It is the world, it's the biggest lottery on the whole world. And in Brazil, it is so strong that they are even behind, for instance, the creation of Carnival, as we know it in Rio de Janeiro. One of the most striking features of Brazilian culture was actually created and supported by the owners of the animal game lottery. So that is just to understand how this phenomenon is pervasive in regards to the whole country. And again, the prohibitions go on and on. And so alcoholic beverage, it was also forbidden. That they turned out the regulation some years ago. But nonetheless, we can see street vendors selling alcoholic beverages all around the city, outside public events. That's one of the most important squares there. That's called Dragão do Mar. It's one of the most, so to say, cultural places of the city. And then, as you can see, it is full of street vendors, no? And all of them without a public permission to sell it, because you not only need the permission to sell, to occupy the public space, an authorization to that, but also a specific authorization to sell alcoholic beverage, because there are much more restrict regulations for that. For instance, if you are a minor in Brazil, you cannot drink alcoholic beverage, but I'm pretty sure that everybody started to drink before you were an adult. And if you see all the regulations, it is really striking how they lack this efficacy in many levels. No? So one interesting case is when we see this street vendors joining together to sell their products. They form what we in Brazil call feiras. Feiras are about open air marts. And we can see open air marts pretty much everywhere. São Paulo has the biggest open air mart in the whole Latin America. No? Feirinha da Madrugada. I hope I can convince him to go there on Saturday. It starts after midnight, more or less at 1 o'clock, and goes until 6 to 7 o'clock. And you can even have 1 million people in one single night there. So you can imagine how crazy it is there. But more interesting is to observe how regulations they apply to this kind of event of open air mart. So if we go to the constitution of the municipality, it says that in its article 107, the following are prohibited: the donation, exchange, sale, lease, concession of use of any fraction of areas of public parks, squares, gardens, or lakes, admitting only the permission to use. And then please pay attention to that. Small spaces for the sale of newspapers, magazines, handicrafts, or snacks, in conditions to be established by the act of the mayor. So it prohibits the use of public space for any other reason that is not a small use of that. And if we see it in conjunction with other norms, such as the one we can find in the Code of Construction and Behavior there, it says quite expressly, it is forbidden, and then we see embarrassing or impeding by any means the free transit of pedestrians or vehicles in public places. So by the very definitions of the laws or the regulations there, open air marts are prohibited. Nonetheless, we can see them all around the town. Yeah, it's amazing. This one, I hope you can see it from there. I will try to show you. It's a Feira da Granja Portugal. It's a neighborhood there. It's specialized on food. I'm not sure if you can see it, but that's the beginning. That's the streets here. I hope you should see too, Henrique, although it might be familiar to you. Can you see this white line here? You see? There are some stalls, orange here and then white. Yeah. Can you see it? It is a line of stalls. They are all street vendors until the end of the horizon. You cannot see the end of this. It is just one street, because there are many other streets crossing this street. So if we take the regulations, it is forbidden to embarrass, for instance, the walking of pedestrians or vehicles. It is impossible for a vehicle to go inside it. And if you were new, as I was the first time I was there, once you get into, you might get lost, because it seems like a labyrinth. So then you can imagine how striking the phenomenon is. And that is just one single open air mart there in Fortaleza, and we estimate that just there in the city we have about 68 informal open air marts, just like this one, 68, and I'm talking about just one city in the state of Ceará, and then we have many others. But anyway, and that's not even the biggest one, by the way, the one I showed you. The biggest one is this one here, Feira da Sé. It's specialized in clothing and tissues in general, and it happens in the city center, just in the core of the city center. Here is the cathedral, you're seeing it just in daylight, but it also happens after midnight, and it gets crazy, not as much as here, because here we're talking about millions of people, but to a certain extent also we can see many different street vendors there. And it's really interesting, this case, because that's the cathedral, that's the city center, and just behind the cathedral we can find the mayor's house. That's from where the mayor regulates the town. And just in front of his house is the largest and the biggest open air market in Fortaleza. No? So you can imagine the amount of problems we can talk about here, at least under the perspective of the legal system. No? So when public authorities, they try to remove or to seize goods there, it might get really problematic. Last time, 2 years ago, they tried to do this in a big operation. They joined more or less 100 and something public authorities, including police and the army. And nonetheless, about 10,000 street vendors, they tried to resist there. And so they got trapped into, and then we had to call more backup, and it was a huge mess. But because we are talking about here of a space that, despite all the regulations, these regulations lack social efficacy. And then I come to my conclusions, in the hope you are still awake. That's the kind of arena inside the states that is highly regulated by stated law, that if we resort to those traditional sociological categories that was stated by Teuner, we can hardly describe this kind of phenomenon. But at the same time, if we go to those new sociological categories, then we might get a clue. We might get a clue of what kind of phenomenon is there happening inside the state. But according to Teuner, and he advocates this thesis, that in order to describe the global law beyond the state, we need a theory of legal pluralism. And then that was the first point I was concerned about. So should we resort to this kind of theory, a theory of legal pluralism, to describe what is happening inside the state? And my answer is no. It doesn't seem that we are talking about here different legal orders or different sources of law that are self-organized inside the state and creating a different legal order or a different law to this purpose. But rather, we are just talking about the state law, which is valid, which is homogeneously valid, but to a certain extent, in some dimensions, has no efficacy. So we are talking about a valid but non-efficacious law, in which those traditional sociological categories, they do not work to describe it. Because in these arenas, the state, it plays just a secondary role in, not in producing, but at least in adjudicating or enforcing legal norms. The state becomes just a stakeholder in order to make these norms effective. And this can be seen the way the state regulates this activity with the street vendors. And then there are some cases in which they come up with some sort of negotiated regulations to say the time they should use the streets, so after midnight until 6 in the morning, and Saturday after 2 o'clock, and Sunday all day long. In each way, some sort of negotiation that goes beyond the law, that goes beyond the law in the sense that it creates all the type of law that it's not revoked in the sense of its validity. And even if we go to some theories of legal pluralism that are stated or are quite famous here in Brazil, I will not go into details regarding these theories. It seems to me that we could not apply them to these very specific cases because we cannot see their organized or institutionalized law, as you can see, for instance, on the law found on the street at the school that is advocated by a professor. It was Lira Filho, and it's very famous in the University of Brasilia. But we can see, for instance, in indigenous communities. So we are talking about very traditional communities that they have their own regulations, their own standards to deal with their own culture and communication. But it's highly implausible to talk about when we are seeing those arenas of street vendors. So just to finish my observations here, then I came up with this idea of presenting a segmented efficacy, because what is misleading when you apply the legal pluralism and you see that there are many legal words that we cannot see inside these arenas, but we rather see how the state law it has a lack of social efficacy, but only in regards to very specific dimensions and branches of the law. The one I presented to you here was an administrative law, and it lacks a social efficacy, but when we go to civil law or consumer law, the contracts, associations and organizations, that is pretty efficacious in the sense. And so when we go to courts and we see cases, we see how these laws are applied and they are valid in these arenas. So instead of explaining the phenomenon through a legal pluralism, then I bring this category here of segmented efficacy. I hope I could make my argument clear here, and thank you very much for all the patience until this time.
Thank you, Professor Moita. Now we have a little time left. I would like to open the microphones for the audience. If the audience wants to address questions to the lecturers of tonight, please feel free. I would only ask you to come here and ask your questions at the microphone.
Oh, that's unfair. That's unfair. No.
Yes, please come here.
There's a guy from Ceará, né? You're very proactive.
Thank you very much. I have a question to Professor Bora. It's about the today debate in Germany about sociology of law. So, is there a debate about how important is sociology of law to law teaching and law profession in Germany? And another question about this: do you see any problem in the law profession that can be linked to the absence of the sociology of law in faculty? And that's all.
Okay.
Thank you. Before the professor answers the question, I think it would be more productive if we collected all the questions and then the answers. So, is there more questions? Maybe Professor Henrique? Yeah.
So, going very short and quickly with my question. Edvaldo Moita. So, you talk a lot about social efficacy, lack of social efficacy in these regulations and laws. So my question is, have you tried to address these questions in terms of social adequacy? It's one possibility to overcome norms. In Portuguese, is adequação social. So if you have, it's most developed in criminal law, Eugenio Hausa Faroni, but you can also use in civil law. So this law, and it may be, it's not a problem in your work, but it's a suggestion to address this social movements from this social adequacy instead of only a lack of efficacy. So,
thank you. More questions from the audience, maybe from the lecturers? Okay, so we can start with the answers. First, Professor Bora.
Just take let me. Well, thank you, Lincoln, for both your questions. The answer to the first question is simply no. There is no debate. There is no debate on sociology of law at all in Germany. So, yeah. The second point, are there problems in jurisprudence or in the world of law that could be linked, attributed, ascribed to the lack of sociology of law? Or the other way around, questions and problems that could perhaps be treated better by integrating insights and informations from sociology? Yes, I would say so. I would say so. My argument in the presentation was the other way around, but I would agree that there are such issues and problems. Henrique talked about Handlungstheorie, theories of action, implicit or explicit theories of action in legal theory, and that is one example, for instance, where jurisprudence, as I would say, has somehow missed the debates in philosophy, psychology, neuroscience, biology over the last 5 decades. Nobody anymore is talking about intentions and the free will and all these things. These are typical constructs, theoretical constructs, conceptual constructs in jurisprudence, and well, that is one of the points where more interest for the developments in the social sciences could perhaps somehow change the debates within jurisprudence. Well, other more trivial example, for instance, is what is currently called legal tech or law and artificial intelligence. This is one of the fields where the traditional concepts in legal theory and in jurisprudence are significantly under challenge, and I think this is one of the fields where cooperation between sociology or sociology of law and legal theory could be very productive by, for instance, debating the question whether algorithms can be persons in the old-fashioned sense. Do they have a will, or can they communicate a will? Can they, maybe you have heard about smart contracting. 2 machines making a contract. That's a very relevant and interesting development in Industry 4.0, in the new developments in industrial production where machines are working autonomously. They draw the decisions. There is no human being behind the machines anymore. And there are machines in factory A, they order spare parts in factory B. And from a judicial point of view, this is a contract. So how can machines make contracts? How is that? It is empirically, it's possible, obviously, but how we do that integrate in legal theory. And this is one of the points where communication theory in sociology and legal theory could well cooperate and inspire both sides. So one example, for instance, so I can imagine, yes, I do. Yeah, I would like to ask some, or to make a comment on Henrique. We had it today earlier. You suggest goes to Gabriel and your really interesting research on the housing financing system. I wonder whether you in your methodological part, did you also check the comprehensiveness of your material? If I understand you correctly, the result is that the discourses you identify are very closely linked to types of organizations. Human rights organizations promote normative discourses, and economic organizations promote economic discourse. Okay, well, I would be interested if you systematically tried to find other discourses that do not represent this very close parallelity or congruence between organizations and discourses. But provocative critics could say that's not surprising. That's what everyone expects, that the OECD produces economic art. But therefore I would like to know, are there other discourses, or did you systematically try to find phenomena that do not fit in this strong parallel?
I'll give some time to Professor Henrique to prepare the answer. Yes. Now Professor Moita will answer. Yeah.
And then
Yeah.
Well, I'll make it short. Thank you very much, Henrique, for the question. It's actually, I have thought of it, but instead of using social adequacy, I use the term social acceptability. That was a different term in my research, which I carry on, not in this article specifically speaking, but in the doctoral dissertation, yes, because there is some sort of spaces in the city in which illegal activities, they are socially acceptable. You find this legitimation to happen. Yeah, but it's interesting how this discourse, it enters the courts. So you gave a really good point here, which is the criminal law, penal law, and criminal cases. But it is highly disputed if these activities they have this social acceptability or social adequacy. And there are, I mean, it is not. You cannot find a consistent way of dealing with these activities, and there are some cases. There are many cases in which some judges, they find the activities that you could apply for them, those principles, such as the bagatelle principle. So it's a misdemeanor, it's not a heavy crime, so it would not be that much important to punish them. But sometimes it happens in a more diffuse manner, such as drug dealing. So we have drug dealers, which is an activity that is not primarily concerned with the street vending, but in Brazil, if you are caught in drug dealing, which is some sort of heavy crime, but if you have you are first-time criminal, you do not integrate criminal organizations. If you have a good behavior, and then comes another point, if you do not practice or you do not live from illegal activities, then you can have your punishment diminished. And then the discussion comes whether this drug dealer, the guy is a street vendor. Is a street vendor an illegal activity for the purposes of diminishing his punishment in the cases of drug dealing? So that's the very discussion, whether if the activity is socially acceptable or not. And then there are many cases that reach even the Constitutional Court. And at least my findings is you find a very inconsistent way of dealing with this concept of social acceptability of these activities, at least in Brazilian courts. So far as I have collected many other decisions. I have not read all of them, but that's the first provisional finding I would give right now. Thank you very much.
So very quickly to Professor Bora, I think the care that I or we need to take, it is not only concerned to normative expectations, or we may not as well with a lot of care talk about communications. Yeah? Not to mention other concepts in systems theory or social theory. So thank you for your comments, and I just wanted to say something about that. Thank you. I will have one last fast question to Professor Gabriel, which was about his PhD doctorate. He studied very different organizations, like Secovio, which is this organization that represents business interests, and also MTST, which is this social movement that represents homeless people. So I would like to know a little more about how his experience was in observing such different organizations by the systems theory framework.
Thank you very much for both important questions. I think that they are connected, so I will try to answer together. First of all, I think that my interest in this case study in the beginning was to understand the tensions between law and economy. So I tried to select organizations that produce those kind of communication. But it was interesting also see that, for example, in local level, as Fernando mentioned, it was possible to see that economic organizations, business associations, work also on courts, work also on lobbying, and so on. So it was possible to see this kind of what it can be named as a kind of polyphonic organizations, something like that. So it was possible to see some main functions that then, such as economy and law, or economy and politics, and law and politics. But also it was possible to see that the documents that they produce are connected to other social and functional systems. So they produce technical studies, they produce articles for newspapers, and so on. Yeah, it's possible to see this kind of other rationality, other systems that they use to communicate. Yeah, I don't know if I answered these complex questions. We don't have enough time also to develop more these, but yeah, thank you.
Thank you, Professor Gabriel, and I would like to thank our guests of tonight, Professor Henrique, Gabriel, Professor Edvaldo, Professor Alfons Bora. I would like also to thank the organizing committee and invite you for tomorrow's conferences, which will happen in this very theater. Thank you very much, and goodbye.